So I have an update in the forced reset trigger lawsuit against the ATF, which was just heard by the Fifth Circuit. So let's break down what just happened. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have great supplements, their protein powder, their pre-workout, all of those. They're pro-freedom, pro-America. They believe in the Second Amendment. Their owner, Andy Frisella, has a podcast that talks about a lot of the same values that we cover here on this channel. So if you're interested, check them out. Use the links down below. And if you use my unique link and you order something $50 or more, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, I have some important news in the battle against the ATF and the restriction on forced reset triggers. You may recall that earlier this year, we received some news from a lower court, Judge Reed O'Connor, who granted NAGR and Rare Breed their motion for a summary judgment. And that was against the ATF and ultimately a vacatur of the ATF's FRT rule. That means that he reached a final decision striking down the ATF's FRT restrictions, finding that the actions were unlawful and were in excess of what the ATF could do and what authority they had. That decision came in the critical case NAGR versus Garland. However, now this case has been appealed to the Fifth Circuit, and oral arguments were just heard in front of the Fifth Circuit 3-judge panel on this issue of whether or not Judge O'Connor got the decision right and whether or not the Fifth Circuit should reverse his decision. Now, this entire case arises out of the unlawful actions by the ATF trying to change the definition of what a machine gun is under the GCA and the NFA. In response to this, Rare Breed then filed multiple lawsuits, but most recently, Rare Breed partnered with NAGR to file a lawsuit against the ATF in the Northern District of Texas. And that case was assigned and heard by Judge Reed O'Connor. I also want to mention that while the Texas lawsuit was going on, there was another lawsuit in the New York District Court, and that was also decided, but that went against Rare Breed. So Rare Breed has a negative decision against them up in New York. But in this specific Texas lawsuit, Judge O'Connor originally granted Rare Breed and the plaintiffs their request for a preliminary injunction. The lawsuit also moved forward with NAGR and Rare Breed, seeking a motion for a summary judgment. So they wanted to win the case before it went to a full hearing, and they requested that the lower court judge there, O'Connor, rule in their favor and grant a motion for summary judgment. And on review, Judge O'Connor again sided with the Pro 2A side and struck down the entire ATF restrictions on FRTs. In reaching his decision, Judge O'Connor again relied on the analysis in Cargill, and he cited to the recent Supreme Court 6-3 decision in Cargill, finding that single function of the trigger is not a single pull of the trigger. Judge O'Connor stated in his ruling that function and pull are not synonymous. The former is based on a mechanical perspective, whereas the latter is based on the shooter's perspective. He went on to state that applying the guidance from both Cargill decisions, here FRTs do not fire multiple rounds with a single function of the trigger and thus do not qualify as machine guns. So we all knew that the Cargill decision was going to have important trickle-down impacts on other ATF cases, and now we got a win in the FRT case because of what happened in Cargill. Now, in that ruling, Judge O'Connor also ordered two main obligations for the ATF. The ATF has to return about 11,000 FRTs within 30 days. That was the original order. The ATF was also ordered to provide notice to all individuals that are involved with this issue who maybe were impacted by the ATF's restrictions on FRTs. Now, like I mentioned, the ATF had asked for Judge O'Connor to issue an extension of that, and Judge O'Connor did agree to provide them an extension, so they are not required to actually do the full return of these items or to provide the notice until next year. Now, along with all of this, the ATF also filed for an appeal in the Fifth Circuit, and the Fifth Circuit has now heard oral arguments on this issue. Now, the three judges that heard oral arguments in this case were Dennis, Southwick, and then also Engelhardt. Now, during the arguments, the ATF was asked by some of the judges, well, wouldn't the FRT arguments being made imply and ultimately lead to the determination that mechanical bump stocks can also be restricted by the ATF, despite what Cargill said in their ruling? The ATF was trying to distinguish Cargill. They were trying to say that the Cargill decision by the Supreme Court and also the en banc panel in the Fifth Circuit does not impact FRTs. And so they're saying that the FRTs in this case are more concerned about the mechanical FRTs and how they operate, whereas bump stocks were more about shooter input and they didn't modify the trigger at all or any of the standard mechanics of an AR-15. So they were trying to distinguish Cargill in the ruling there by the Supreme Court and how it focused maybe on the difference between mechanics and just shooter input. Now, the judges here, I don't believe, actually were persuaded by that. In fact, at one point, one of the judges stated that when they sat on en banc panel review in Cargill, he was actually in the dissenting part of that, which believed that bump stocks could be regulated as machine guns. And he stated expressly that he got that wrong. Based on what the Supreme Court said in Cargill, his prior determination was incorrect. And there was a lot of emphasis by the Supreme Court on the actual trigger input and the mechanics of a trigger. The ATF here with the FRTs is saying that you should ignore all of that. And he is saying, well, he ignored it prior when he ruled against Mr. Cargill on the en banc panel review. And so if he did that again, he would be making the same mistake, and he doesn't want to make the same mistake. So that was a very interesting comment by one of the judges here on the Fifth Circuit. Now, the ATF also during their arguments brought up a lot of questions about organizational standing. The ATF's position in this case and other cases is that 2A organizations like NAGR do not have organizational standing, that they can't sue on behalf of their membership. And so they were bringing into question whether or not this was even a valid lawsuit and should have been thrown out by the lower court. The ATF claims that there is no way for them to know all the members of organizations like NAGR or how they could ever actually give those members notice or return of items because the individuals are not expressly named. There was also some questions about the relief that was granted by the lower court Judge O'Connor. Now, here is where I think maybe the ATF could get a slight win. The ATF's main position was that Judge O'Connor issued too broad of relief when he vacated the FRT restriction entirely. So under the APA's rules, a vacatur, in my opinion, would be the appropriate type of relief, but the ATF is saying that that relief was too broad. They want the Fifth Circuit here to limit the scope of relief to just the individuals named as plaintiffs in this lawsuit. Now, in response to that specifically, the Pro-2A side said that requiring all individuals to be named in this lawsuit would just simply be absurd. That's not how this operates. And they also argue that the default remedy when it comes to APA lawsuits like this one would be vacatur of the entire rule. And the ATF is only taking issue with wanting to limit the scope. And they want to do that essentially because they still want to be able to enforce this specific rule, which, oh, by the way, was found invalid by this court. They argue that the ATF has revealed what they actually want to do, which is limit the relief in this specific case and then still apply the general rule selectively in other circuit courts and other jurisdictions and try to target individuals and then make it a burden on that individual to prove that maybe they're covered by an organization like NAGR. So the ATF still wants to be able to enforce this FRT restriction, despite the fact that the court here would find that these are not covered under the NFA or GCA. And the Pro-2A side said, well, why should the ATF even be trying to apply and enforce the rule to anyone if it's vacated as unlawful? Now, the last section was very interesting because one of the judges asked, well, after Cargill, did Congress at all try to modify some of the statutory text to include bump stocks or even go after FRTs? And both sides said, no, there has been no action by Congress. And if Congress wanted to target these items, well, then they should do it statutorily. And that's also what the Supreme Court said in Cargill. There's been no activity, no action on any of these items. The ATF does not have authority to do it on their own, and therefore, again, this entire lawsuit should be dismissed. So there were some very interesting arguments in front of the Fifth Circuit on this issue of FRTs. I think the Cargill decision is going to be clearly persuasive. Even one of the judges in the prior dissent in Cargill said that he got it wrong prior and he doesn't want to make the same mistake. So I think that's one win there. I think if the ATF is even going to get a slight win, it's going to maybe be some form of limiting the scope of relief, maybe saying that Judge O'Connor was too expansive in vacating the entire rule. And maybe the Fifth Circuit would say that he needs to just apply it to the individual parties. But even if it is, this will get appealed to the en banc panel in the Fifth Circuit, and we're going to see what they have to say about that as well. So as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.